Hey, welcome to My Court Coach. I'm Jalen, and I'm going to be your instructor as we navigate through Form DV-180, Agreement and Judgment of Parentage. Now, this form is used only when both parents agree to be named as legal parents of their children. So the parents have to complete sections 1 through 9. So you do need to have this completed before your restraining order hearing, because this is only within the context of a restraining order. And if the court does order child custody and visitation, but yet you don't have any court orders stating that you are the parent of the child or children, then this form would help establish that parentage. And that's especially if you do not have the intentions on filing a paternity action and you only want to just have a restraining order action on file, and then this is the best way to establish that parentage. So, and it says agreement and judgment, so that means this is going to be the final order. If you sign off on this, there is no going back unless you are facing fraud, duress, coercion, one of those things that would allow for the judgment to be set aside, meaning to be undone. But that's going to be rare in a case like this, where you are going through a domestic violence restraining order and the judge asks you whether you want the parentage to be entered, and it's only done by an agreement anyways. Protected person. You're going to write your name and then what is your relationship to the children. So the mother, the father, if you have your lawyer is going to complete this information. You can write your mailing address if you do not feel comfortable providing your residential address. You don't need to provide your telephone number, your fax number, or email, but if you do have an attorney, the attorney would fill out those portions. The restrained party would provide their name and then what's their relationship to the children, whether they're the mother or the father, and then their mailing address. And you'd want to use the address that is on file that is consistent with your request for the domestic violence restraining order. Agreement on parentage. So there's no other parentage case. So you both do not have a pending case elsewhere relating to your children about paternity. So you're stating that you are in fact the parents of the children listed below, and these are the children that are listed below, and you need to write their date of birth and their sex, and if there's more than just 4 children, then make sure you use this MC025 form, and then just type in DV-180, and then type in the children's name, date of birth, and gender. So the best of both of your knowledge, there's no court case in which someone other than us claims to be or is alleged to be the parent of the children. So like the other parent's grandparents are not claiming to have custodial rights over your children. That's an example that there's no other court case pending relating to somebody else trying to take parentage of your kids. No court has ordered or found that someone other than us is a parent of the children, so there's not going to be any conflicting orders. There's not any other paternity case out there that says Joe and Samantha are the parents of Alan, Bob, and Sandra or something. There's no pending adoption or guardianship case for the children. So there's no adoption case and there's no guardianship case for the children. And this is important because you can't be the parents of, the legal parents of a child that is going through an adoption. The adoption case would actually have to proceed first before your agreement on parentage. And then same goes with the guardianship case. You are stating that you guys cannot be, you are the legal parents, yes, but the guardianship case would establish that those guardians would be the legal parents of the children. So if there is a pending case about guardianship, then that case would also be resolved first. No other person has signed a voluntary declaration of paternity for the children. So mom didn't have somebody else sign a voluntary declaration of paternity for the children. This voluntary declaration of paternity for the children is usually signed at the hospital. So if nothing was signed at the hospital in terms of somebody stating that they're the father, then more likely than not, no other person has signed this voluntary declaration of paternity. The mother was not married to another person when the children were conceived. So what does that mean? It means that if mom was married to her husband and let's say she had an affair and she ended up getting pregnant by somebody else, well, by law, that child is actually the product of the husband and wife relationship, even though she had the kid with somebody else. So the court by law would say that the husband is in fact the dad, or legally he's the dad. And so there's a whole process to get around that, but she must not be married at the time of signing this, and also not have had the child when the child was conceived during their marriage. So make sure you write your name up here and your case number, and then the orders that you're requesting is you're asking the court to find that you two are the legal parents of the children and to enter a judgment of parentage. So to enter a final order that you two are the legal parents. We ask the court to order the children's birth certificate to be amended by adding the father's name or changing the last name of the children. And this is something that you don't have to necessarily do, but it is a good idea to amend the children's birth certificate so you have it as an order so that you can, or the father can, add his name to the birth certificate at some point. And then if you two wanted to change the last name of the children, you can do that, but you don't have to agree to that and you don't have to request that. If you sign this form, you will give up these rights. Right to a trial. You can ask a judge in a separate case to decide if you are the parent of the children in this case. You can bring evidence and witness to that trial, and you can question the witnesses against you. So if you resonate with any of these statements, then you shouldn't be signing this, because then you're actually having some doubt as to whether you actually are the father of the child. So if you do feel that there might be a mistake or even a 1% chance that you might not be the father of this child, don't sign this. File a paternity action, ask for a DNA test, and make sure that you are the father of the child. And you can actually get the DNA test prior to signing this agreement. So if you can tell the other parent, the mom, hey, I want a genetic test of some sort. I want a DNA test. I'm going to pay for it because I just want to make sure that I am the father of this child. And oftentimes the other parent gets offended, like, how dare you think that you're not the father of this child? And, just kind of read through or hear past that. Don't take that so seriously, because you do have a right to that genetic testing, and you should obtain it before signing this form if that is what is going to give you that confidence that you are in fact the father of this child. So the next thing is the right to genetic tests. So you can ask a judge in a separate case to order genetic tests to see if you are the parent of the children in this case. The court may order you to pay for those tests. So exactly what we were saying earlier is that you can ask the court to order a genetic test, and if you don't necessarily have an agreement with the other party to do the genetic test, then you are going to have to ask the judge to do the genetic testing. And it's not going to be under a restraining order context, but you could file a paternity case like we discussed earlier. So number 7, if you sign this form, the court may decide you are the legal parent. And actually, the court will decide that you are the legal parent if you do sign this form. So the court may order you to pay child support, So child support may be taken out of your paycheck without notifying you. Child support can be a lot of money, and it usually lasts until the child turns 18. If you do not support the children as ordered, you can face criminal charges. Pay other expenses and costs. The court may also order that you pay other expenses for the children in this case. You will have all the legal duties of a parent. So this is some of the things that you're going to be obligated to do when you are found to be the parent of the children or child. Now, before you sign this form, you can hire a lawyer. So if you wanted to consult with legal counsel about this prior to signing this form, please do so. It says if you can't even afford to pay for a lawyer to represent you, call the local bar association for help, or you can ask the court's family law facilitator's office for information on how to find a lawyer. It's always best when you are agreeing to something so final like this that you do hire an attorney, or at least speak with an attorney as to what your legal rights are and to explain what it is to be a legal parent. Now, sign below if you understand and give up your rights. So you're saying that we are the legal parents of the children. If either of us has a lawyer for this agreement, that lawyer has read and explained this information to the parents being represented, and that person understands it. We have read and understand this form. And if someone's translating this form, we understand the translation. And when we say give up your rights, it's literally these rights right here. This is what you're giving up. So you both must sign this form if you read and understand the rights listed in it. You both give up these rights and freely agree that the court can make orders naming you both as legal guardians or legal parents of the children listed on this form. We declare under penalty of perjuries under the laws of the state of California that this foregoing is true and correct, and this is important. This is specifically true for this part right here, A, B, and then 1 through 5. And then you sign it and date it. And then you need to write your name up here. And then the judgment of parentage. So now the court's going to find you to be the father, mother, father, whoever names needs to go here. But as long as there's a mother and a father. The parents of the children, so their names are going to be listed here. And if there's more children, please make sure you use this MC025 to add that to the orders. And the court is going to order that the last names of the children are changed. So that's only if you request it, or if you request the birth certificates be amended so that it conforms to this order by adding the child's last name. Or adding the father's last name, you can go ahead and do that. If there's any other orders that you're requesting, then the court can order that as well. The number of pages needs to be listed. So if you have those MC025, you'd probably have 2 of those, one for the request to include all the children's name, and the other is the order relating to all of the children's name. And then the notice of entry of judgment. So the parties must provide self-addressed stamped envelopes and 1 original and 2 copies of the completed notice of entry of judgment. So it has the form FL-190, and you do need to complete this form and make sure that you do bring 2 self-addressed stamped envelope. So 1 for the original and 2 copies of the notice of entry of judgment, and the 2 copies, one is going to go to you and one is going to go to the other party, and that's why you need 2 self-addressed stamped envelopes. And you want to have the return address to be this court, so depending on which court you're in, you're going to go ahead and provide that address on there. In case it doesn't get to you for whatever reason, it can go back to the courthouse, and the courthouse can at least potentially call you to ask you about that. So the judicial officer is going to sign off on this, and they're also going to date it. And then if you did have an interpreter at the time of you signing this, then that interpreter also has to sign this. So they have to say if they read or translated or interpreted this agreement and judgment of parentage to the best of their ability, to either the protected person, the restrained person, who said that he or she was unable to read or understand the English documents. His or her primary language is whatever it is, could be Spanish, and he or she now understands this document of perjury under the laws of the state of California. The foregoing is true and correct, and now you have the name and date and signature of the interpreter, which this is actually very helpful because in the event that somebody needs to undo this final order for parentage, you could use the interpreter as a witness. So hopefully you found this to be helpful, and best of luck.